Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. I hope you guys are having an amazing Friday. Hope you guys are doing well today. All right, so this is a Diddy update. As you can see with the little thumbnail, if you looked into it, you'll see I was dropping little cheesy hints about what's going on. I feel like this man is definitely spazzing out. He is not used to being behind four walls for this period, a long period of time. Diddy is used to getting, everything that he wants at any time of the day, and it's just not happening at the MDC. It's not happening. I am very surprised that he has not fired everybody on the defense counsel and hired new people. But then again, who is going to take on these cases? I don't even know. So we're going to hop right on into a couple of things. Um, First, we're going to talk about the notes that was retrieved from his cell during a sweep. He's not too happy about that. So what the defense counsel is really trying to do is saying, "Hey, you guys took all of this information. You took, pictures of notes, and you sent them to the prosecution and you didn't notify us. How much do you really know?" And that's what they're scared of. Now, is it right that they did that? No. How they went about it, they should not have gone about it that way. But that's a fight right now. So it's a big issue of whether or not those notes, those privileged notes, can be used in trial, or during the duration of this litigation. The second part is this laptop. They are still, they in the motion, the last renewed motion for bail, they have made it very, very clear that he is unable to prepare for trial. And if that is the case, then you are violating his, amendment rights, because everybody is, entitled to a fair trial. So if he can't properly prepare for trial, he's not going to have a fair trial. That's what their defense is right now. So they're saying he needs this laptop in order to prepare for trial so he could review discovery. Now, in my opinion, Combs has not followed rules at the MDC. He has not followed any type of rules that he placed in these motion for bails. Like, you're saying, "Oh, I'm just going to talk to these people," or "I'm just going to," you're not doing it. You're calling family members. You having them make three-way calls, which is against the BOP procedures, and I think any bail, not, I mean, any jail procedures or prison. You are still intimidating witnesses and jury and so on and so forth. You're using other inmates' PAC accounts. Like, you're just doing some shady stuff. So why do you think that you're going to have access to a laptop? Make it make sense. But without further ado, let's go ahead and hop right into this. All right, so what you see on your screen is a letter, or I don't want to say a letter, it is a notice of a motion for a hearing suppression and other relief. This document has been filed by Diddy's defense team. They are wanting a hearing, they are wanting something to be suppressed, and whatever other relief that the judge or the court sees fit, they wish that they can grant. But this is just a request from the defense counsel. So it reads that, please take notice that upon the declaration of Tiny Geragos, Esquire, dated on December 4th, 2024, the exhibit attached here to and the accompanying memorandum of law, defendant Sean Combs, by and through his undersigned attorneys, will move this court at the United States Courthouse, 500 Pearl Street, blase, 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 at a date and time to be determined by the court. for an order. So this is what they're asking. The defense counsel is asking for discovery and a hearing. As we know that there is a lot of discovery to go through from what they, retrieved from the raid, but they also have discovery coming in probably on an everyday basis. You have all of these civil suits, and those can also produce evidence to use in this criminal trial. So the defense counsel is like, we need to have a set date that discovery is received so that they have time to go through it before trial. Now, in a couple of motions ago or responses ago, the government said that they can try to have discovery done by the end of the year, which I'm assuming December 31st, because they have trial on the 5th of May. But whatever they get, they have to allow the defense counsel to review all of that so they can also prepare for trial. Now, this has been going on since what, March? And we are in December. So, how many months are they? So they have to give that same time for the defense counsel. That's why I say I don't think, honestly, in my opinion, that this trial is going to be happening on May 5th. I do not. The second thing that they're asking the court is to suppress Mr. Combs' privileged notes and any fruits of the illegal search. 3, directing that a special master conduct privilege review in lieu of the filter team going forward. Because what happens is anything that comes from the FDC, oh, not the FDC, Lord, the MDC has to go through the filter team, and then the filter team will distribute it to the prosecution and to the defense, right? But I don't think that's happening because the incident with the BOP investigator, he actually took the photos, sent it to the filter team. The filter team redacts whatever information they need, and they sent it to the prosecution. They didn't even send it to the defense counsel. So pretty much they want somebody that can oversee this and make sure that the procedures are followed to a T. Let me see. The fourth thing they're requesting to consider whether any or all of the prosecutors must be disqualified because they were tainted by access to the privileged material. So, because now I could have sworn that the investigator went straight to the prosecution. I didn't know he went through the filter team, but whatever the investigator knew, he went straight to. I thought that's what happened. He went straight to the prosecution team with everything. So I hope that makes sense. So if it goes to the filter team, some information is redacted, but because the investigator had knowledge of everything, he went to the prosecution, he spoke to the prosecution, and so they have this information. And so the defense counsel is saying, hey, we don't know how much information that they have, but whatever information they had, that it's not good. They're already tainted because they have access to this privileged information. Ordering the government to stop monitoring Mr. Combs' communication with the defense team. We understand that it is attorney-client privilege. However, Diddy, you have not been following any of the rules. Any of the rules. So we don't know what you're talking to your defense team about. I I get it. It is attorney-client privilege. I do get that. However, the way his history has been at the MDC, using other jailmates' PACs, calling family members, having them do three-way calls. Really? The last thing that says, subject to the evidence adduced at the hearing, dismissing the indictment. So they're saying, man, y'all didn't got all this privileged information. Y'all didn't follow protocol. Just go ahead and dismiss the indictment. That's what they're at. That's what they're wanting a hearing for. They want to discuss all of these matters. All right. So, with that, to back it up, they actually filed a memo in support of their motion for a hearing suppression and other relief. Now, I'm not going to go through all of this, but they pretty much broke down the what happened with the investigator at the BOP. If we recall, the BOP had a suite, and it was for to I believe search for the DRUGS and all that other stuff, right? So the MDC did ask the BOP investigator to be a part of that. During the sweep, the investigator didn't go to his cell. He went to Diddy's locker and searched the locker and found the manila folder, the legal pads, and other information that he took pictures of, and he sent. Now, based off of this document, they said it was sent to the filter team, and that the filter team redacted some of the information and sent it to the prosecution, but did not send it to the defense. So it's, I don't know. I think their timeline is a little bit off. Um, and then once the government got that information, they filed in opposition to Diddy's motion for bail, because they're saying, hey, here's what we found out. He does not need to be released. So that is the biggest thing right there, is them using these notes. Well, when I say them, the government using these notes, knowing that they got it from the BOP investigator illegally. They calling it a legal search, because the sweep was for one thing, but this investigator, who was not an employee, did something else. And so they didn't follow the procedures in the first place. So that's why they're trying to get it booted out. What their argument is that they're saying, hey, because this investigator went into our client's cell, illegally took, screenshots or pictures and sent it to the prosecution that gave them a leg up, that violated the attorney-client privilege and Combs' Sixth Amendment right. It also violated Mr. Combs' Fourth Amendment rights, because at the end of the day, y'all are not allowing this man to have a fair trial. If he can't prepare for trial, right, because he doesn't have access to certain things, how can he have a fair trial? And I'm not saying this, that's their argument. Um, Discovery and a hearing are required, because once again, the government is constantly getting new information on top of what they have to go through. So there has to be a time period, and I do know that some federal cases do have what we call a scheduling order, or a docket control order, where it has dates where certain things has to be submitted at a certain time. As I stated in the beginning of this video, there is a lot of discovery or evidence that has to be gone through on the government side, and they have to produce that to defense counsel so they can go through it, Diddy can go through it, and they can prepare for trial. That's why I said I don't think May 5th is going to happen, but we shall see. They're also saying that this court should order appropriate remedies, use of fruit suppression, appointment of a special master. They want somebody other than the filter team to go through the information that they receive from the MDC, and see what information is a current attorney-client privilege, what can be submitted to both the prosecution and the defense team. Dismissal of the indictment, and disqualifications and other potential remedies. I want to see what their reasoning for dismissing. And I read the introduction so we can kind of get a clear indication of what's going on. Based on the information already known, it is clear that the government has violated the Sixth Amendment by intruding on the attorney-client relationship and interfering with Mr. Combs' relationship with counsel and his ability to mount the best defense he can muster. The extraordinary violation of Mr. Combs' Fourth and Sixth rights also constitute outrageous government conduct and violates his Fifth Amendment right to due process. Dismissal of the indictment may therefore be warranted upon development of the full factual record at a hearing. Dismissal is appropriate not only where the conduct of the government has been manifest and avowedly corrupt, but even where the conduct merely involves intentional intrusion into the attorney client domain, resulting in prejudice to the defendant's case. For example, okay, so let me go back. They actually cited Scrimmer 2, and then also Walters, where it says dismissal warranted in cases of outrageous government conduct. So the way that the government has been conducting themselves, defense counsel is not liking it, and they're like, hey, they're not, being truthful. They're not following, procedures and protocols. So this case should just be dismissed. And then they gave an example. So in Stein, the Second Circuit affirmed that dismissal of an indictment against numerous defendants charged with a major tax evasion scheme because the government had interfered with their ability to retain counsel of their choice. The court affirmed Judge Kaplan's ruling that no other remedy would restore them to the position they would have enjoyed by the government's unconstitutional conduct. Moreover, even as to some defendants who were not deprived of their chosen counsel, the remedy was appropriate because the government had interfered in their relationship with counsel and impairment of their ability to mount a defense, including by impeding the scope of their pretrial investigation and preparation. Stein supports dismissal here, even though the government's misconduct has taken a different form in this case. The unconstitutional surveillance of Mr. Combs' notes about the preparation of his defense and privileged communications with his counsel has interfered with counsel's ability to provide effective assistance, just as the unconstitutional interference with counsel's fees did in Stein. Here, for example, although we do not yet know the full extent to which the prosecutors have used the privileged information, they cannot unlearn the preview of the defense strategy they have obtained, nor can any other violative use of the privileged information be undone at this point. Mm, I hope everybody's understanding. So, in a nutshell, because the investigator went to the prosecution and told everything that he found in Diddy's cell, what the defense counsel is saying, they can't unlearn, even though you could destroy all the evidence, you can't take back what they already read, what they already know. And that was the biggest thing. Now, the defense strategy, why would you write that down on a piece of paper? But and that's the biggest thing there, because if y'all remember, when they went to court on the 19th, I believe, the photos showed legal being written on, I believe, two legal pads and not on others. But when Diddy came to court, all the legal pads had legal written on them, and the judge questioned that. And so that is why right now it's a debate on whether or not those notes can be used in this trial or in this litigation process and trial. It says specifically the government already admits it has one, listened to Mr. Combs' calls, including with family members and his attorneys. I wonder why, because this man is using his family to call third parties to reach out to people. Two, reviewed his messages, including with dozens of individuals, including attorneys. And as is clear from the government's reliance on Investigator 1 and its bail arguments, the government has not hesitated before affirmatively deploying Mr. Combs' privileged communications against him. Here is the thing: Diddy keeps violating the rules. He keeps there should be no third party calls. People have said that he is reaching out to other people. He's not above anybody else. He's not above any other prisoner in the MDC facilities or any BOP facilities across the country, right? If you are not following the rules and you continuously breaking them, I don't think that they could just say, "Oh, okay, don't listen to the attorney calls, don't check the messages and all this other stuff." And if you do that, who is to say that Diddy won't be like, "Okay, I'll pay you an extra X amount of money if you could, three-way call somebody for me." I get why they are constantly, reviewing all his calls and all his messages because he's not following the rules. Who we let me see. All right, and it says to make matters worse, the communication at issue clearly gave the government a preview of defense strategy. In Skimmer, they said that the problem in this case, however, is not that the government obtaining incriminating statements or other specific evidence, but rather than it obtained information about Danielson's trial strategy. And so okay. That's what they're upset about. So, whatever paper or papers that was related to how they're going to go through this, litigation process and trial, now the prosecution knows, and that's a problem. That's why they're so gung ho on whether or not they can be used. Those notes that were obtained can be used. But the question is, even though we know that investigator was not supposed to do what he was supposed to do, but on those notes or the legal pads, did it have legal on there? That is the question. Because how is he supposed to? I mean, obviously, if you're reading that and you comprehend, oh, this is how they're going to do this, in the litigation process. But realistically, he didn't have anything indicating that this was attorney client privileged. So they can kind of fight that. But this is what the defense is upset with. They know the defense strategy. The notes reference strategy to discredit particular allegations and corresponding witness testimony. Mhm. Is that why you're using people to call outside and speak to witnesses? Anyways, let me go back. So the notes, this is the strategy: to discredit particular allegations and corresponding witness testimony. 2, to obtain a specific type of expert witness for trial. And 3, to collect cross-examination material on particular witnesses. Thus, the prejudice to Mr. Combs' defense is clear and dismissal could be appropriate. So I can only imagine what was on there, to be honest. So if he has notes, he probably had individual names on there of witnesses and notes up under them. And that's why the the investigator took them and say, "Hey, look at this. Look what I found." I don't, yeah, he wasn't right, but at the same time, if it don't say attorney-client privilege or legal on there, then it's free game. It remains to be seen whether the government put Mr. Combs' privileged information before the grand jury or made other use of the information. But notably, the government has never denied such use, nor has it disclaimed any intent to so use the notes in the future. To the contrary, it stated it would shy away any suggestion that we put them in a vault and lock them up. So yeah. So this is their support to this motion. Now the government came back and said, oh wait, hold on, am I missing something? Oh, that is 97, 98. Where's 99? That's the laptop. 101, talk about the laptop. Okay. So the government replies and said, hey, we are requesting a motion to pretty much change the briefing schedule in connection with the motion that was filed, that I just read, for the motion for hearing and suppression and all that other stuff. So remember when the judge ordered the government to get rid of the copies of the notes, right? The issue was, can they use the photograph notes now in trial? So the judge ordered for the defense counsel and the government to submit documents to the court in regards to that. So he stated that the defense needs to file a motion by December 4th. The government needs to file an opposition to that motion by the 9th of December. And then the defense needs to reply to the government's opposition by December 11th. So the government proposed the following adjournment, which would provide a government a similar amount of time to respond to the defendant's brief as the defendant had to draft and file this brief. So they are requesting that the government opposition be due by December 20th and defense to reply to that opposition by the 27th. So it's like we gotta go, we have to make some time to go through the defense motion and reply accordingly. And it says the government respectfully submits that the proposed schedule will afford the government adequate time to respond to the merit issues raised in the defendant's brief, specifically given that the government's case team cannot respond to a certain arguments advanced in the defendant's brief regarding privilege because the case team is no longer in possession of the notes at issue. The government must add an assistant United States attorney to the filter team to make that response. Additionally, given the breadth and scope of the extraordinary relief requested by the defendant, an adjournment is appropriate because, mind you, they're asking for a hearing on discovery, and not a hearing. They are asking for a hearing for discovery, but they're asking for an additional hearing. They're asking for the court to suppress the use of any of the privileged information that was obtained. They're asking for dismissal, so on and so forth. So the government has to reply or provide a response to each of those because this is the memorandum. It's wait, hold on, where'd it go? Yeah, this one right here. This is 31. They have to go through all the arguments and counter that. So that's 31 pages that they got to go through. Let's see. Moreover, it says that the defendant will suffer no prejudice given that the case team is no longer in the possession of the notes at issue. So they're saying that y'all, your case, the defense counsel case, is not going to suffer because we don't have the notes. We don't have the notes no more. This is the first request for an adjournment. The government has asked defense counsel for their position on the government's request, but has not received a response. And the parties are scheduled to appear before the court on December 18th, 2024. I need to see exactly what that hearing is for. So then the defense counsel comes back and they said, okay, we are writing in response to their request for an extension. And they said, while we do not oppose a reasonable extension, we request that the briefing schedule to be complete within 2 weeks so that the parties can be heard on the issue at December 18th conference, which would make more sense. Okay, just get everything done at this hearing before the holidays so we don't have to extend. I'm thinking the government is like, we need some time. So that's why they did it after the hearing. So that way, once they submit all the documents on the 20th and the 27th, then they'll schedule another hearing, and that would kind of push everything back. I see what the government is doing. But the defense counsel said, let's just wrap this up on the 18th. So it says, accordingly, we propose the following briefing schedule. Government opposition due December 12th, and the defense can reply by December 16th, which is an extra week should accommodate the government's request, especially in light of fact that these issues have already been raised, and because the government's filter team is already led by an assistant United States attorney in office. And that was stated in the November 19th document, obviating any need to add an assistant United States attorney to the filter team. Moreover, the government is incorrect that no prejudice will ensure from further delay, as the government is actively pursuing new leads and gathering new evidence based on unlawfully acquired information. Okay. So what they're saying is like, look, they have obtained new information from this. Well, let me take that back. Because the investigator shared what he's seen on those documents to the prosecution is like, oh, okay. So that gave them new leads, and that gave them the opportunity to request, either subpoena or request records or evidence based off of what the investigator told them. So what they're saying, like, no, it is gonna hurt him because we don't know the extent of what all you all found out, but we do know that all of these new leads and this new evidence that you guys are gathering is because of the information you got from the investigator who took pictures of the notes. So they ain't having that. They're not having it on that. So that's the debacle with the notes. So let's talk about this laptop. So last time we spoke, they were trying to get this laptop to Diddy because they say, hey, there's a whole lot of evidence that Diddy has to go through. And the only way he could go through there is if he has a laptop. I personally don't want to give this man a laptop. You know why? He has proved to us that he can't follow basic rules. He uses other inmates' accounts. He calls family members to do three-way, and God knows what else. He's still reaching out to people on the outside world other than his family to try to intimidate them. If he gets his hand on a computer with the internet, no telling what he will do. Because remember, contact me ASAP or whatever that messaging service was, dude. He is not. He's so used to getting his way. He's so used to getting whatever. If he say I need this, he's used to getting that. And he's struggling. He's struggling right now. But here is the government's response to this laptop. So it says the government respectfully submits this letter in response to the defendant's letter submitted yesterday regarding the defendant's use of a laptop to review discovery at the MDC, as well as the MDC's provision of attorney visitation forms. Oh, yeah. So they are upset that the visitation forms are being sent to the prosecution as well. Because here, and I'm thinking while I'm reading, I'm wondering, why do they need the visitation forms? Is it to see if he's actually meeting with the, attorneys, or if they're trying to find a pattern? Because if you're going to use this laptop, I think you should only use the laptop when you are scheduled with your attorney and you're supervised. But I don't even trust the attorneys because, like I said, he could be paying them on the side. Who knows? But I think that's why they're asking for these visitation forms. But then it says, for the reasons that follows, the government respectfully submits that the relief requested by the defendant is premature or mute. In the normal course, pretrial defendants housed at MDC review discovery during designated hours using computers within their housing unit. Oh, let me see what footnote. CBOP inmate admission and orientation. Ooh. MDC inmates are also permitted to access computers in the law library for legal research. Well, there you go. This boy, that's what I'm saying. Diddy, you can't get your Diddy treatment in the MDC, my boy. You got to follow like everybody else. So this, they make it seem, I'm thinking that they didn't have no computers. If that's the case, take your butt to the law library. In exceptional cases, particularly those with especially voluminous discovery, courts in this district have permitted certain pretrial defendants to access laptops preloaded by the government with discovery material so that those defendants can prepare for trial while in custody. That's a reasonable accommodation. In the United States versus Hernandez, it says that ordering the government to load air-gapped laptops with non-sensitive discovery for defendants review at the MDC. They also stated United States versus Smith, where ordering the government to preload discovery on a laptop for defendants review for discovery at MDC in cases involving massive amount of discovery material. They also cited United States versus Ulbricht, where, let me see, noting that just because the case has a high profile does not mean it requires special treatment, but also noting that the court has had gone to considerable lengths by ensuring that a laptop preloaded with certain discovery material was provided to the defendant for the use at the MDC. Here, based on information provided by MDC legal staff, the government understands that out of the approximately 25 other inmates in the defendant's unit at MDC, only 3 other inmates are permitted access to laptops, including the defendant in the Hernandez case cited above. Huh? What Hernandez case? Oh, man, y'all know what? I was thinking about the Menendez brothers. Boy, I'm about to say what? I'm tripping. All right, so in the exceptional cases where discovery laptops are permitted, defendants' access to the laptops is subject to restrictions, including the hours during which the laptop is available, the location where the laptop may be used to review discovery, and prohibit on copying and transferring discovery materials contained on the laptop. So that's good. So the discovery will already be uploaded on there so he doesn't have to go outside of, the drive to find the discovery. In Hernandez, let's see, it said the defendant was permitted to access discovery laptop Monday through Friday in the MDC visiting room for 10 to 15 hours per week and requiring defendant to execute agreement that he would not share contents of laptop with other inmates, among other restrictions. In Smith, they permitted defendant to access the electronic device for review on a temporary basis and at times approved by prison personnel, and contemplating use of the laptop where defendant is not in the presence of any other inmates. In United States versus Zukovic, no, Zukov, it stated that they granted defendants' request to use Discovery laptop at NDC and ordering that no one besides the defendant and defense counsel may review the contents of the computer, and that BOP personnel will provide the defendant reasonable access to the computer in one of the MDC's visiting rooms. I love when the government comes back and slaps them and sets them. It's like, because the defense counsel be trying to make like the MDC and the government is not being reasonable at all. And they come back and say, hey, there's already laptop. There's a whole law library there. Why can't he go there? Huh? Why can't is he above going. And if he has to review discovery, okay, that's fine. You could take this approved laptop and you could go to this room and you can review it. See, Diddy is trying to get all full blown right access to a laptop where he could do pretty much any and everything on it. If it can connect to Wi-Fi, he's good to go. He can text messaging service on there. He can use something to make a call, call out on the computer. He can do a lot of stuff. And that's what he's trying to get. No, my boy, you need a pre-downloaded Discovery laptop, and that's it. In this case, the government's agreed to provide certain discovery on a Discovery laptop for the defendant review at MDC. Oh, wait a minute. Oh, excuse me. So the government has agreed to provide certain discovery on the Discovery laptop for the defendant's review already. So it is the defense fault. If they don't accept that, that's y'all fault that he's not able to prepare for trial because they have provided you with certain discovery already. So what's the holdup? The government began producing discovery immediately after the protective order was entered on October 4th. Here we are, December 6th. So that's 2 months he done missed out on discovery because he wants to be a baby. At the request of defense counsel, the government first prioritized producing defendants' electronic devices and accounts, which were designated as attorney possession only, or APO, under the protective order. Given the APO designation of these materials, the defendant was not permitted to retain them at MDC. The government produced the bulk of the discovery that the defendant is permitted to retain at MDC, consisting mostly of subpoena returns and other documents that defense counsel had not requested the government to prioritize by November 2024. At that point, the government had begun loading the Discovery laptop providing by defense counsel and delivered the Discovery laptop to the MDC on November 25th, 2024. The majority of the documents loaded onto the Discovery laptop are designated as sealed under the protective order. Now it reads, sealed material may be disclosed by defense counsel to the defendant, who may only review such material in the presence of BOP or law enforcement personnel, defense counsel, or any personnel for whose conduct defense counsel is responsible. I have been saying this. So, what is the hold up, defense counsel? They made it seem that because in a letter, if y'all have not, go back and watch the whole Diddy playlist. The government stated that they sent the laptop for the government to review and it's just sitting there and they haven't given it to the defendant. But here it is saying that the laptop is there. Majority of the documents have been loaded to the laptop. And the only way that he can view these is if he is in the presence of BOP, law enforcement and personnel, defense counsel, or personnel whose conduct defense counsel is responsible. So the ball is back in the defense court. What are y'all doing? Well, it's not even in it's not even in their court. It's in Diddy's court. So because you don't want people to see what effed up stuff you done, is that it? Are you embarrassed, my guy? I think he's embarrassed. Let me see what these footnotes says. Across the entire MDC, which houses approximately 1,250 inmates, the government understands that there are approximately 25 inmates who have access to Discovery laptops. And then the letter. So this is in regards to the Discovery laptop. So it says defendant's letter also claims that the defendant needs the laptop to take notes about his case more generally. However, that goes well beyond the authorized purpose of the laptop, which as noted above. Exactly, because it's just a Discovery laptop. You just open up, click on your discovery, review, and that's about it. Let's see. Smith says, and I'm at the footnote down here. It says permitting the defendant to make notes on the discovery, but not for note taking more generally. Permitting laptops for other purposes would create unjustified disparities between the defendant and the vast majority of the pretrial defendants housed at MDC. So, what they are saying is it would not be fair for Diddy to be able to pull up a Word document and make notes when other inmates are unable to do so. On December 3rd, 2024, MDC legal staff contacted the government to discuss where within the MDC then it could review the discovery laptop. As the government understands it, the following options are available for the defendant to review discovery on an approved laptop. So mind y'all, they already said this is how you can access the discovery laptop and when you can use it. It's Diddy who's being difficult. He wants all of these things his way and it can't happen. So if he can't get ready for trial, that is on him. And I'm pretty sure the courts is looking at it's your fault. It's not the government's fault because they have already provided you with the resources and the times that you can use it. You are just not wanting to do it because it's not your way. So let's look at this. The defendant could access the discovery laptop privately in his unit visiting room 7 days per week from approximately 8 a.m. until 3 p.m. Mm-hmm. Number two, the defendant could access the discovery laptop privately in his unit's video conference teleconference room, which is occasionally used by other inmates for scheduled VTC legal calls on Monday through Thursday from approximately 8 a.m. until 3:30 p.m., with the exception of other inmates are scheduled to use the VTC room for legal calls. Or three, the defendant could have unfettered access to the discovery laptop in defendant's unit without regard for the presence of other inmates on Monday through Friday from approximately 8 a.m. until 3:30 p.m. In the case of any of the three options, and consistent with the MDC policy and prior cases addressing the same issue, the discovery laptop must be returned to the MDC personnel after the defendant finished reviewing it for the day. The discovery laptop will be kept in a locked area of the visiting room beyond the hours that the defendant may access the discovery laptop. However, the defendant may use discovery computers within his unit until 9:15 p.m. to review any discovery on hard drives provided to the defendant by defense counsel. Due to the sensitive nature of the sealed materials contained in the discovery laptop, which include the names of victims and witnesses, as well as travel and financial records for the third parties, option 3 is inconsistent with the protective order in this case. Pursuant to that order, the sealed material must not be viewed by third parties. The defendant, therefore, must not be permitted to roam throughout his unit and among other inmates using the discovery laptop. Instead, he should be required to review these materials privately in a designated location and outside the presence of other inmates. In short, option 3 does not sufficiently protect these sensitive materials from potential disclosure, purposeful and inadvertent, and therefore is not tenable option. All right, so he only has two or three. I mean, not two or three, one or two. Those are the only options you got. As the government understands it, the MDC's limited bandwidth makes it difficult to combine options 1 and 2. Specifically, with respect to option 2, MDC legal personnel must transport the discovery laptop from the visiting room, where it will be kept overnight, to any other area of the defendant's unit, including the VTC room. MDC legal personnel has indicated its willingness to do so. Should the defendant prefer to access the discovery laptop in the VTC room, where he would be able to meet virtually with defense counsel while accessing the discovery laptop. But the defendant asserts that option 2 is unsatisfactory because despite generally providing for several hours a day of access 5 days a week, it would significantly limit the time available for Mr. Combs to use the laptop. So, once again, this is him. He doesn't want to do it because it's not his way. He wants to have access to a laptop 24/7, more than just discovery. In conferring with defense counsel, the government suggested that the defendant choose option 1 or 2 and revisit the issue should problems related to the defendant's access to the discovery laptop arise. Defense counsel instead made the instant application to the court, seeking the court to order the MDC to permit the defendant to use the discovery laptop in his unit without restriction, vaguely arguing without citation that any other arrangement would be a departure from the normal MDC practice. In fact, as described above, either option 1 or 2 is entirely consistent with how courts in the district and the MDC have handled discovery laptops for other defendants. The government respectfully submits the defense counsel's application is premature, as either option 1 or 2 accomplishes the goal of providing the defendant with immediate access to the discovery laptop while also ensuring that sensitive sealed material be treated in accordance with the protective order in this case. The defendant has also requested the court to order the MDC to cease providing the government with attorney visitation forms, which the MDC routinely provides when a defendant complains about inability to access his attorneys. I'm going to read that again. The defendant also requested the court to order the MDC to cease providing the government with attorney visitation forms, which the MDC routinely provides when a defendant complains about inability to access his attorneys. First, these visitation forms, which disclose only the fact of an attorney visit, are not privileged. Because if you say you can't access your attorneys, but we submit these forms and it shows that you've been, meeting with your attorneys 5 days a week, you lying. HDW Carter and Sons versus William Carter, I'm sorry. That was cited because it states that the attorney-client privilege does not extend to facts pertaining to the existence of an attorney-client relationship, the fact of consultation, or the dates and general nature of legal services performed. Second, the defendant squarely put his access to defense counsel at issue in connection with his renewed motion for bail. Because remember, he was saying he can't prepare for trial adequately because he doesn't have access, to do this and to do that. So yeah, but you lying. That's why they showed this. You do have access, so you fine. Like I said, the MDC is providing him with a reasonable accommodations to do everything it is that you need to do to prepare for trial. You're just trying to find a way. I don't know. Maybe like, are you slow or something? I really think this man is slow because do you not think that they're going to come back and say, rebuttal and provide receipts? Because the government is coming with receipts left and right. Um, Let me see. So it says that due to the MDC lockdown, defense counsel was delayed in meeting with Mr. Combs, losing time for trial preparation, and that the defendant has been hampered in collaborating with his counsel. That's what he stated. So that's why they was like, let me show you these visitation forms. Finally, the government has no intention of collecting such materials absent the defendant again putting his access to counsel at issue. Accordingly, this request is now mute. For the reasons said above, the government respectfully submits that the defendant's requests with respect to the discovery laptop are premature and that his request in respect to the MDC providing the government with attorney visitation forms is mute. Because at the end of the day, they gave you access to a laptop and they gave you two options on when you can use that laptop. And two, You keep complaining about not being able to access, adequately with your attorneys, but yet the visitation forms say otherwise. Make that make sense. All right. So now let's see what the defense said. They said, let me go ahead and respond to this. So we write in brief response to the government's letter regarding Mr. Combs' laptop. So, first, contrary to the government's argument, Mr. Combs' reasonable request for laptop access is consistent with the way other inmates in his unit access their laptops. Other inmates are permitted to use their laptops in the unit, notwithstanding the fact that their laptops also contained sealed materials subject to protective orders. There is no reason to treat Mr. Combs differently. So they cited United States versus Bankman Fried, where the defendant was able to use a laptop between 11 a.m. and 7 p.m. on weekdays and 8 a.m., 3 p.m. on weekends. And then in United States versus Maxwell, it says requiring the MDC over objection to provide laptop to defendant on weekends and holidays, in addition to 13 hours per day on weekdays. The government's argument that Mr. Combs' request could create unjustified disparities is just wrong. All right. So if they do extend the time that he uses it, at the end of the day, it still need to follow the guidelines of the MDC. Mm. Let's see. They said second, the government's opposition to Mr. Combs using the laptop to take notes about his case more generally is absurd as a general matter, and particularly in the context of this case where Mr. Combs' handwritten notes have been so they try to say because his notes has been photographed, they no longer trust the people at the MDC or the BOP investigators. So that's why they feel more comfortable for him to take his notes on the laptop. Get out of here. Let me see what they cite. The government cites to the laptop order in United States versus Smith, where the government was required to load onto the laptop such software as defendant will need to review and make notes on the discovery. But that order, jointly proposed by the parties, does not contain any prohibition on the taking of other legal notes. Ah, I mean, okay, because I don't know what is on those particular laptops, but let's say that they open up in PDF. I know PDF has where you could actually make comments on it. You can highlight, you can do all that other stuff. So if he's able to access those tools, then that should be it. But I'm thinking he wants to, I'm thinking he wants more than that. He wants like Microsoft Office. So yeah, that's not happening, bruh. Of course, any such prohibition would be ridiculous since notes on the discovery are inextricable intertwined with notes about his legal case. Requiring Mr. Combs to record his notes about discovery separate and apart from his other legal notes is unreasonably burdensome and completely unnecessary. It is especially unreasonable in light of the government's history of. Oh my gosh, really? The monitoring of his handwritten notes. Hold on. Let's see. The government's request that Mr. Combs continue to handwrite legal notes, subjecting them to further surveillance by the government is unjustified. It is inconsistent with how other inmates use their laptops to create and share work product with their counsel. Let me see. Once again, they stated United States versus Bankman and Fry, where it says noting that laptop will enable the defendant to review materials and share work product with counsel through exchange in hard drives. Anything short of these reasonable requests would unconstitutionally impinge on Mr. Combs' Fifth and Sixth Amendment rights. Yeah, I honestly don't see, in my opinion, I don't see the judge even trying to grant this man extended access or even a software where he could take notes on his laptop because of a past experience. I honestly don't see it. I don't see it. I mean, the government made a good case. They made a very good case. Like, hey, these are the hours that you can use it. Now, let me see. I'm trying to go back and see. They didn't cite enough cases for me because only that was 2000. This case was 2022. United States versus Bankman and Fried, and then the other case was 2020, and they were provided. Now, I could see him possibly extending that because in the government notes they said that he can access, but here's the thing here. So the government is saying that he can access the laptop privately in his visiting room 7 days per week from 8 a.m. to 3 p.m. The second option is he can use it privately in his unit, the VTC room, Monday through Friday from 8 a.m. to 3 p.m. And then let me see. So they're saying that in one case they allowed it from 8 a.m. to 7 p.m. on weekdays and 8 a.m. to 3 p.m. on weekends. I mean, bro, you just got to deal with it. Cuz I'm wondering how much discovery that they also had in those cases. I got to see. But yeah, so that's the update. That's the update. So in a nutshell, y'all, let me close these tabs. So in a nutshell, like I said, there's two issues that's going on. It is the illegal use of the notes. They're trying to determine whether or not they can be used in trial. The second thing is the laptop issue. It has come out from what I just read is that they have the laptop. It has the preloaded discovery on there. Diddy is just being weird and he doesn't want to view the laptop because he wants to be able to do other things on the laptop. He's wasting his own time. If he cannot prepare for trial, it's because he's refusing to prepare for trial. They already made the accommodations for you. What more do you want? And why do you want a laptop so bad? Y'all tell me what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Until then, y'all be blessed and I'm out. Bye.